Hello, my name is Patrick, spokesperson for Mediation instead of Court.ie. In this video, we'll be looking at some frequently asked questions concerning the process of mediation. What is the cost of mediation? Well, we charge on a per-hour basis and don't charge any retainer. The fee does depend on the complexity of the case, so please contact us for a more accurate figure. Is there a lengthy waiting list? No, we aim to meet clients as soon as possible once contacted in order that matters can be resolved as soon as possible. How long does mediation take? Mediation usually takes a good number of hours to resolve any situation. Our mediators will move as fast as the parties are able or willing to move. However, if you are both willing to set aside a good number of hours, you might see resolution by the end of one day, or perhaps a second in certain cases. Sometimes parties meet the mediator over a number of weeks, and this usually takes approximately 6 sessions on average to resolve. Is mediation just for people who want to split up and end a relationship? No. Mediation can be used to help parties explore new ways of communicating and resolving their differences without splitting up. However, both parties need to be willing to explore this possibility with the help of a trained mediator. If the other party is very difficult, can I meet with the mediator to inform them of this situation? Yes. Often parties tell our mediators about their individual situation. This can greatly help the process if the mediator gets a full understanding as to what type of personality the other party possesses. I am nervous about sitting down with my ex-partner. Can we meet the mediator separately? Yes, you can if you so wish. It might help if you met with the mediator first on your own to discuss your point of view and familiarize yourself with the process and indeed the mediator. The mediator is used to dealing with people like you in situations like this and will control the situation. The mediator will help to create a safe environment to express yourself, be heard, and as a result hopefully resolve matters. You can also take breaks as often as you like, as it is informal. Do you offer a local service? Yes, all of our mediators will meet you in your local area and can arrange for suitable locations for meetings. If the other party often controls you and every situation you are in, will this continue to happen at mediation? Each party will have as much time as they need to express their point of view and be listened to. The sessions are in a controlled environment where your mediator will control the process. This also includes using ground rules agreed upon by both parties, which the mediator will enforce in order to keep the mediation productive for both. The mediator's role is to use various principles, including empowerment and fairness of process and outcome for both parties. What happens at the mediation session? Well, please see our other videos for information on this. However, you are not on trial at mediation. You will not be cross-examined, and it is an informal process. Neither party is there to prove that they are right and the other is wrong. The whole process is geared towards finding solutions that are agreeable to both of you with the help of the mediator. Will I be forced into agreeing something if I'm not 100% happy? No. The mediator will not be content for you to feel you have to sign a document. The mediator will speak with each of you separately if necessary in order to tease out matters to your satisfaction. What if I want my solicitor to advise me? Parties are welcome to get any advice they feel necessary during the process in order to enable them to make the best decision possible for themselves. Can my solicitor advise me on the agreement before I sign it? Yes. You can obtain the agreement once completed and ask your solicitor to advise you. If you would like it changed before signing, you can both return to mediation. If I agree to one session, am I committed to the process? No. Mediation is a voluntary process. All of our mediators charge on a per-hour basis. There is no retainer for our service. If you feel the process is not getting anywhere, you can ask to end the process. You needn't feel any pressure, as it is a voluntary process. What if one party does not want to attend? Perhaps ask them what they have to lose. Why not attend one session and see if it is for them? Or perhaps they could have a talk with the mediator and see if their needs will be met at mediation. the mediator will be keen to hear both parties' point of view. Is mediation successful? Yes. We currently have an 88% success rate. The reason being that, unlike court or arbitration, you decide on your preferred outcome. If we reach agreement, is it binding? Yes. The agreement reached is drafted up by the mediator, and it is binding between you both. There is no best before date on this document, so you can keep it and it will last into the future. Do I lose my right to go to court if I choose mediation and it fails? No. You can still use the court process if the mediation is not successful. In addition, you can request a mediator to draft a report for court which can be used to help you both reach agreement that could not be achieved at mediation. What if agreement is reached and one of the parties breaks that agreement in the future? If agreement is reached at mediation and one of the parties breaks that agreement in the future, you can go to court to have that agreement enforced by a judge. However, this is rare, as at mediation the parties decide the outcome, not another person. The other party talks all the time with family, neighbours. They all know what's going on. Will the mediation be in private? Yes. At the first session, we all agree to keep matters private. If you would like to nominate one or two people that you both may like support from, this can be agreed once both parties agree to this. Otherwise, there is merit in keeping matters between the parties. Could what I say at mediation be used against me in court? The mediator destroys all notes once mediation is complete. The parties agree not to ask the mediator to testify or provide notes from the sessions. This is important in order that both parties feel they can discuss matters and decisions openly with the other party and mediator. Parties agree to keep matters confidential at our first session. How do I choose the right mediator? This is a very important question. You need to be able to trust your mediator with this very important situation you need resolved. All of our mediators are qualified solicitors who worked in the courts for a number of years before retraining as mediators, have obtained a diploma in mediation, have current practicing certificates to act as mediators, and professional indemnity insurance. Finally, all of our mediators have worked in this profession for upwards of 6 years. Please note that other mediators may operate differently to some of the answers given, but the above is how our mediators at Mediation Instead of Court.ie operate. All of our mediators are Irish, fully insured, certified, and work as full-time mediators. Our mediators have also worked as solicitors in Ireland and have also qualified in England and Wales. However, legal advice is not given. Parties can draw on the mediator's experience working in the courts. As I've stated, our mediators can travel to meet with you in your local area, as we have clinics in many cities and counties at a time that suits you both. Hopefully you should have enough information to help you begin the process of mediation. We welcome you to call us on 087 9832 112 or visit us at mediationinsteadofcourt.ie. Thank you for watching, and please peruse our other videos on our YouTube channel, Mediation Instead of Court, or visit our website if you would like further information on www.mediationinsteadofcourt.ie.